Good afternoon, everybody. Thank you very much for joining this afternoon. I'm sorry for the slightly delayed start. I'm Fay Collinson, barrister and mediator at King's Chambers, and this afternoon I'm going to talk to you about direct payments under the Care Act 2014, specifically whether a Property and Affairs Deputy can and should be managing them. This topic is a bit of a hot topic at the moment. I know that the judgment of SBB, in which I acted for the Deputy Dan Lumb, has caused some heated discussions amongst deputies. So what I plan to do today is not really focus on the Lumb decision, although I am going to deal with that in some respects. If you want to know about the Lumb decision, Stonegate and I did a seminar a couple of months ago, but I'm going to deal with specifically Care Act direct payments. So just to set out expressly the four key areas that I'm going to deal with. First, just to set out the legal framework, because I think to understand the conclusions that I draw from the various decisions, it's important to understand legal framework to that. Secondly, I'm going to have a look at the case of Calderdale and AB, which also concerned the same deputy as in the SBB case. Then I'm going to have a look at parts of the SBB decision. And then I'm going to set out some of my own conclusions. And I never normally have to say this on a webinar. I think this is probably the first time. But I hasten to add that by this webinar, I'm not seeking or purporting to give any of you advice on the way in which you should run your own deputyship. So I know from speaking with lots of deputies since the Lumb decision was handed down that it is causing some real practical difficulties in how you manage your caseloads. And many of you I'm currently advising on how you deal with that. So please don't rely on this webinar when coming to your own decisions as a firm about how to manage direct payments. Many of you have also sent in a number of questions, and I've gone through many of those, in fact, all of them. I can't possibly seek to try and answer all those, but what I am trying to do in this webinar is I've got those in mind and will certainly direct the things I talk about to hopefully help you with those questions. So let's start with the Care Act. Three bits of law that it would be a good idea to go and just have a read off when you get some time to do that. In the Care Act 2014, the key sections are 31 to 33. Then we've also got the Care and Support Direct Payment Regulations 2014. And finally, we've got the Care and Support Statutory Guidance, which is, as many of you know, a very lengthy document. But the key parts about direct payments are at Chapter 12. It's also useful to refresh your memories of Chapters 10 and 11 that also deal with personal budgets. So just having a look at the basis or the power by which the local authority can make a direct payment. And for those of you who might not be as familiar with direct payments as other people, the Care Act is about local authority direct payments. For ICB direct payments, so CHC funding, NHS funding, that's under the 2013 regulations and the NHS Act 2006, which is the focus of the Lumb decision. So we're thinking about local authority direct payments. So I've broken Section 32 down into three component parts for when a local authority must make a direct payment. And here we're dealing with individuals who lack capacity. There is, of course, the power to make direct payments to people who don't lack capacity on this relevant decision. But most of you, in fact, probably all of you who are listening to this webinar will have keys who lack capacity on these particular issues. So the first is that he has to lack capacity to request the local authority to meet any of their assessed needs by making payments to the adult. So pausing there, a person who has care and support needs has, in principle, a choice about the way in which their care is delivered. So that can be directly commissioned. It can also be provided by way of a direct payment. And the rationale or the aim of direct payments is to give somebody choice about the manner in which they receive their care, so that they can perhaps employ friends or people that they trust to provide their care, rather than have individuals who change every time somebody is unwell. So that's the first part. The second is that where we have someone who lacks capacity to make that particular decision, that request has to be made on their behalf. And the person who does that has to fall within the definition of an authorised person, which, for the purposes of the question, which is the title to this webinar, is a key bit for us. And then, finally, conditions 1 to 5, which are set out in section 32, must also be met. And I'm going to go into those shortly. So we start here with who is an authorised person. And just pausing there, in the 2013 regulations that deal with ICB direct payments, the authorised person is known as the representative. So slightly confusingly, the two bits of statute and statutory instruments call the person by different titles. So the person who can be appointed as the authorised person falls into 3 different types of groups. The first is that the person's authorised under the MCA to make decisions about the adult's needs for care and support. Then we move to B, where the person is not authorised, as mentioned in paragraph A. The authorised person can be a person who is so authorised, agrees with the local authority that the person is suitable to whom the direct payment, to whom to make the direct payments. Or finally, where the person is not authorised, as mentioned in paragraph A, and there is no person who is so authorised, the local authority considers that the person is a suitable person to whom to make direct payments. So, as usual, pretty tortuous language. So what I've tried to do is set that out a bit more simply. So hopefully I've achieved that. So I take the view that section 32 sets out a hierarchy of individuals who can act as the authorised person. And that marks a difference, I think, with the ICB direct payments, because under the regulations there, the way they are phrased doesn't, to me, suggest that there is a hierarchy, i.e. you have to kind of clear off each person as you move down the ladder. So the first person who can be the authorised person is a person who is authorised under the MCA to make decisions about P's care and support needs. To me, that is, in other words, what we all term as a health and welfare deputy. The second group of people who can act as the authorised people or person is someone who isn't a health and welfare deputy, but a person who the health and welfare deputy and the local authority agree is suitable to make the direct payments to. So if the health and welfare deputy doesn't want to be the authorised person for whatever reason, we move to point 2, which is they can, with the local authority, agree that another person is suitable to take on that role. So you can see that there is consultation with a health and welfare deputy as we move down the ladder. And finally, where there is no health and welfare deputy appointed at all, we have what I call the catch-all group, which is just a person who the local authority thinks is suitable. And again, pausing there, looking at the 2013 ICB regulations, there was a similar provision, which was the catch-all, effectively anybody who's suitable to do that role. So the first point is we need to have a look at who is an authorised person, but then we have to look at whether the conditions 1 to 5 are met to see whether the local authority must make the direct payment. And I've just summarised these here. So number one is that the health and welfare deputy supports the authorised person's request for a direct payment. So if we just go back to section 32, where we've got here, in subsection B, where the health and welfare deputy doesn't want to be the authorised person, but they agree that somebody else is suitable, that health and welfare deputy has to support that person's request for the direct payment. So I think, in other words, that is effectively that the health and welfare deputy in some way consents to the making of that direct payment. Then we go to condition 2. The local authority is not prohibited from making the direct payment under the regulations, or the local authority has not exercised its discretion not to make the payment. And I've just referenced there regulations 3 to 4. Those regulations regulation 3 sets out when the local authority must not make a direct payment. And there are various instances of that where someone might have a criminal record. And that is also the provision which prohibits, on the face of it, direct payments being made to family members who also live with P and provide care. There is, however, a means to get around that if the local authority thinks it's necessary to make the payment to that person. And then regulation 4 confers a discretion on the local authority to decide not to make a direct payment for whatever reason. And once somebody asked a question about whether the local authority can require people to go through various training, manual handling exercises, things like that. And it occurred to me that person might want to have a think about regulation 4 and whether the local authority could use that to effectively enforce that kind of training. So condition 3, the local authority is satisfied that the authorised person will act in P's best interest in arranging for the provision of care and support. Condition 4, the local authority is satisfied that the authorised person is capable of managing the direct payments. So just to draw your attention to those two, which I think are quite important for the reasons that I give a bit later, is that we see this distinction between management and administration of the payments and decisions about the provision of care and support. Then we've got condition 5, which is the local authority is satisfied that making the direct payment to the authorised person is an appropriate way to meet the needs in question. And before it answers that point in condition 5, it's got to have a look at regulation 5. And again, this is going to be relevant to some of the conclusions that I come to a bit later. So the local authority must take the steps that are set out in regulation 5. And really, these are aimed at consulting various individuals and, of course, consulting P to obtain their wishes and feelings. So in that sense, it's quite similar to section 4 of the MCA, although there is an important difference that I'll deal with in a bit. And the people that the local authority has to consult are anyone named by P as someone to consult on whether direct payments should be made to their authorised person. I think that's probably going to catch attorneys under lasting power of attorneys, because you'll perhaps have picked up from section 32(4) that it doesn't expressly provide a group or for those people who are appointed as attorneys, only deputies. They also have to consult anyone engaged in caring for P or interested in their welfare. And they must also consult any person authorised under the MCA to make decisions about the adult's needs for care and support. So I think what we're seeing there is a requirement on the local authority to, insofar as is reasonably practicable or possible, consult with key people who are involved with P's care and support needs. So that's a sort of a very quick overview of, for the purposes of this talk, the relevant legal framework. Now I'm going to move to the case of Calderdale and AB. And I use the word case specifically and deliberately because this was not a decision of the senior judge after considering full argument or indeed really any argument. It was a consent order drafted, I think, by the local authority and agreed by the other parties. So I think there does have to be a pinch of salt taken with those kind of cases. But in terms of the background, you can't discern a huge amount from the consent order. This was also a matter in which Dan Lumb, the deputy in SBB, was also the deputy in this case for AB. AB was receiving 24-hour care in the community at his home, and that was provided by his siblings, who would take it in turns. I think it's a week on, week off or something like that. And payment for the care they provided was made by way of a direct payment. AB's brother-in-law, with whom he didn't live, was the authorised person appointed by the local authority under the 2014 Act. And as I say, Mr. Lumb was appointed as AB's Property and Affairs Deputy. And it's important in this talk that when I'm talking about an appointment of a Property and Affairs Deputy, unless I say otherwise, that is subject to a standard deputy order. Because, of course, the COP can and often does make specific, tailored deputy orders in certain cases, but most of you will be appointed under the standard order. So here, the issue was whether Mr. Lumb, as a professional Property and Affairs Deputy, could be the authorised person set out in section 32(4)(a). And just to remind you, rather than going back to the slides, is section 32(4)(a) is in these terms. The person is authorised under the 2005 Act to make decisions about the adult's needs for care and support. So, if Mr. Lumb could be the authorised person falling within that description, then the brother-in-law could only act as the authorised person with Mr. Lumb's support. If Mr. Lumb didn't fall within that description, then it was for the local authority alone to decide whether the brother-in-law was suitable to act as the authorised person under the third and final group, the catch-all group, under section 32(4)(c). So as I say, this was a consent order which set out in the recital the local authority's legal analysis, and that was seemingly agreed by the other parties to what was originally a dole's application. And I've summarised here at bullet point 2 the local authority's legal analysis, and it was as follows. A Property Affairs Deputy's authority does not include determination of P's care needs. Well, that should be uncontroversial, and that has been fairly settled and reinforced by the decision of Judge Hilda and re-ACC, and I've put there the relevant paragraph for you. Decisions about P's needs for care and support, which is the term used in section 32(4)(a), include determination of P's care needs. So, a Property and Affairs Deputy is not authorised to make decisions about P's care needs for care and support as required by section 32(4)(a). So, in summary, what was agreed in this case and endorsed by Judge Hilda was that a Property and Affairs Deputy doesn't fall into this description. What the local authority then went on to say was that there was no reason to suggest that if Mr. Lumb had sought his appointment as an authorised person, which he didn't, but if he had, the local authority weren't saying that he was not suitable to act as that person under subsection 4C, so the catch-all provision. So what was agreed there was, first, a Property and Affairs Deputy does not come under the subsection 4A, but if a Property and Affairs Deputy put themselves forward as acting as an authorised person, in principle, they could be appointed under 32(4)(c). That leads to other issues about payment, which I'm going to come on to. An interesting point about the Calderdale case is a point made about ownership of the funds. So in the recital, the local authority referred to the direct payment as public funds, and that these did not form part of P's property that were managed by Mr. Lumb. And of course, if they don't form part of P's property, then as a starting point, or I say P's property and affairs, as a starting point, they don't, the COP doesn't have any jurisdiction to make decisions about that. But that was an approach that differed from that taken by the ICB in the SBB case. So that was a point of real contention between the parties. In the case, there were reduced various draft agreements for direct payments where many ICBs referred to the funds as public funds. And I've seen local authorities and ICBs refer to that numerous times over the years. But the ICB suggested that the monies were P's property. Now, Judge Hilda effectively dismissed that, but what she did go on to say was that even if it's not P's property in the sense that he or she doesn't own the money because they can't do what they want with it, it still forms part of their affairs because they have certain obligations to deal with the money in a certain way. So it's an interesting way of dealing with it, because if the outcome were that the direct payment didn't fall within P's property and affairs at all, there would be nothing that the COP could do about the management of direct payments, which would probably leave the position even more complicated than it now currently is. So just drawing that all to a close on this point, I think what you can take from this is that Mr. Lumb couldn't act as authorised person in his capacity as a deputy because he was a property affairs deputy, but he could in principle act as an authorised person under the catch-all provision if he wanted to, and if the local authority considered him suitable, which there was no reason to suggest that he was anything other than that. But the problem that we have with professional deputies is because, understandably, you want to be paid. So this is why this doesn't cause an issue with lay deputies, because that role is a gratuitous one. But the position is very different with professional deputies, and this is why these judgments and the way the legislation is drafted is causing such a problem. So just to go back to basics on deputy charging, because I often think this is misunderstood as well. We all know that a deputy is a fiduciary owing a number of fiduciary duties to P. The law is such that an agent, so the deputy, cannot charge their principal without their consent. Of course, P can't provide that consent, so the COP has to do it for them. And this is why you see towards the bottom of your deputy order a provision about charging to P. And if your order doesn't have that in there, then you can't charge P. So that's always an important point to make sure is in there, which I'm sure you all do. But here's the important point. The deputy can only charge P for doing acts or making decisions that are within the deputy's power conferred by the order. So what that means is if your deputy order doesn't allow you to do something, then you can't charge P for doing that. And so that's why when we look at this problem, we need to look at what the role of a representative under the other regulations or the role as an authorised person actually entails. So that brings us to this question. Is acting as an authorised person outside the scope of a property affairs deputy's authority under the standard order? It probably is, I'm afraid to say. I know that when I did the seminar with Dan and Matt on SBB, I covered this very briefly, and I was met with a number of emails saying, oh gosh, I didn't realise this. Can you explain to me why you take that view? So hopefully I set out in this seminar why that is. But the reasons really are very similar to those provided in SBB, not identical, because of course the regulations are drafted in a different way. So this is when I go to SBB and just pick out some of the key conclusions to help explain why I come to this view. So the representative under the 2013 regulations, well, let me start again. The 2013 regulations, as you can see from the judgment, set out a number of provisions that require a representative to do certain things. And those regulations are pretty extensive. There's also the accompanying statutory guidance, which sets out the nature of that role in detail. And the inevitable conclusion of considering those two items is that the representative is required to get stuck in to these care arrangements and the planning of them. So that led Judge Hilder to conclude at paragraph 69 that the representative must be able to plan or devise the care arrangements. And as we know from ReACC, a PNA deputy is not empowered to do that. And also many deputies would say, that's not something I'm particularly qualified to do. That's for my case manager. And Judge Hilder emphasised here that it's not simply the representative's role to administer the payment of care arrangements. So I think prior to SBB, there was probably a lack of understanding about the true nature of the role as a representative. Many thought it was just literally getting the funds into the bank account and paying the direct debit to the carers. Maybe on a practical level, that's what a lot of you are doing. But actually, that role requires much more than that if you're doing it properly. So Judge Hilder accepted the submission that it does involve health decisions. And actually at the hearing, the part 2 of these hearings, the IRCB accepted that the role of a representative did involve decisions about health and welfare to some extent. So what that means is that as care planning is not within a property affairs deputy's authority, they cannot act as a representative in their capacity as a deputy under the standard order. And Judge Hilder said that the 2013 regulations envisage a deputy who can make both property and affairs and health and welfare decisions to be appointed as a representative. But the problem that we've got, and that Judge Hilder identified, was that the perhaps drafters of the legislation and the statutory instruments didn't or don't appreciate what's actually happening on the ground with deputies, and that the COPS approach, as we know, is to either appoint a property and affairs deputy or, much less commonly, a health and welfare deputy. It's pretty rare for there to be this sort of hybrid deputy. But the hybrid deputy is what the 2013 regulations and I think the Care Act actually envisage. So if a deputy had agreed to act as a representative, it would and is outside the scope of their order. And what that means is that they cannot charge P for carrying out that work. So that is not only a problem going forwards, but it's a problem looking back. Because if you have been doing that as deputy and you've been charging those costs of acting as representative to P's estate, even if they have been certified, it still doesn't remove the fact that that work was unauthorised. So what Judge Hilder then goes on to say, to think about ways in which the problem could be dealt with, is that in principle, the COP can authorise a property and affairs deputy to act as a representative. And that could be achieved by granting an extension of the authority to the property and affairs deputy. So that's a very quick rundown in SBB. What are the implications of that for direct payments under the Care Act? Well, I said earlier that the 2013 regulations include a number of regulations which set out the duties of a representative. The Care Act and the Care Act regulations aren't as prescriptive. In fact, they don't go anywhere near as far as that. But I think standing back, the likelihood is that the role of the authorised person does involve at least some degree of health and welfare decision making. And these are the points that I sort of have flagged up in enabling me to come to that view. So the first is paragraph 12.3 of the statutory guidance. And I've set it out there for you. It said people should be encouraged to take ownership of their care planning and be free to choose how their needs are met, whether through local authority or third-party provision by direct payments or a combination of the three approaches. So what I think that indicates when you read that paragraph and the whole of the chapter is that having a direct payment, and this is also recognised in the NHS guidance, is about giving the person the choice about how they plan their care and how their care is delivered to them. And Judge Hilda came to the view in SBB that that is out with the deputy's authority. That is a health decision. But I think there are other reasons why I say this. And so I go back to the legal framework. So first, section 32.4 and the hierarchy of people who can act as an authorised person. Well, it seems to me in that hierarchy that a health and welfare deputy has priority to act as the authorised person over other people. It doesn't say there that the deputy is a person authorised to make decisions about P's finances or how their money is managed, for example. There is very much a focus on the person at the front of the queue being someone who makes decisions about P's health and welfare. But even if that person doesn't want to act as it and somebody else is going to do it, that health and welfare deputy still has a degree of control alongside the local authority about who that person is. Because as we know from subsection 4B, the health and welfare deputy has to agree that that person is suitable and they must support the direct payment being made on P's behalf. So even if they're not choosing to be the authorised person, their view is pretty material to who ultimately takes on that role. And I can only think the reason for that would be is because that person is charged with making those health and welfare decisions. And that is seen as a fundamental part of the authorised person's role. So in a way, that health and welfare deputy is sort of exercising some degree of supervision over this person. And we've got some of the conditions that I think are relevant. It says that condition 3, an authorised person must act in P's best interest when arranging the provision of care. So to me, that's going at or hinting at devising or planning the care arrangements. And then if you look at condition 4, that's about the administrative side of the actual management of the payment. So there's clearly an expectation that this authorised person is going to be making decisions about the planning of P's care, and the local authority must be satisfied that person will do it in P's best interest. Then we've got regulation 5. So when the local authority is deciding whether condition 5 is met, then the local authority has a positive obligation to consult any health and welfare deputy. And that goes back to the point I've just made, which is that that person's views are material. And that must be because the authorised person is going to be getting heavily involved, I think, with those types of decisions. And for me, what stood out here was the contrast in the drafting with section 4 of the MCA. So that's the best interests analysis section, which requires the decision maker to, insofar as reasonably practicable, consult with a deputy. It doesn't say a deputy charged with making decisions about health and welfare or care and support needs. It just says a deputy. So there's been a conscious decision to include within this legislation just health and welfare deputies. So for all those reasons, I think the outcome for direct payments under the Care Act is in reality the same as the outcome in SBB. And so these are the conclusions that I draw. First, under standard order, a P&A deputy does not have authority to act as the authorised person. But a P&A deputy could be appointed by the local authority under subsection 4C as someone it considers to be suitable. But here's the important point. That's going to be in your personal capacity. So if we go back to Calderdale and just say, for example, the brother-in-law didn't want to act and Mr. Lumb had said, I'm prepared to take on this role. Here you go, local authority, I'm a suitable person. And the local authority agreed with that. Mr. Lumb would then have been appointed as Mr. Lumb, the solicitor, not Mr. Lumb, the Property and Affairs Deputy. And that has a really crucial significance because it would mean that Mr. Lumb in those circumstances couldn't charge for the work done in that role. So on a practical level, I know many of you, because I've spoken to lots of you about this, many are acting as authorised persons or representatives on many files under the various bits of legislation. And just pausing there, in SBB, there was some evidence from the PDF about what was happening on the ground. Unfortunately, it wasn't as extensive as we had hoped, but it did indicate that this was happening on the ground. So if you are currently doing that without the relevant authority, you can continue to do that, but you just can't charge for it. And I know that some firms are taking a view that they're okay with that. Depending on the particular file, it might mean that the work actually incurred in doing it for that particular P is pretty minimal. And so that firm is sort of taking the view that actually it's just, it's not worth our time to seek authority. So they're just effectively doing that role gratuitously. And that's okay. Although it obviously doesn't deal with what you've done retrospectively if you have charged. So I'm going to come to that in a moment. But if you as a firm, and many firms will understandably take this view, think, well, we're not happy to do that role without payment, that's when you need to think about asking the COP to extend your authority. But the problem there for many of you is that extension of authority is not available where you have a trust corporation. Because for the reasons identified in SBB, health and welfare decision-making cannot be conferred on a trust corporation, only on an individual. So it doesn't seem as though a trust corporation can act as authorised person and get paid for it. It could act as authorised person under subsection 4C and forego payment. But as I say, if it wants to seek payment from P, you must get the authority, but a trust corporation can't do that. One of the things that has been discussed with some deputies is where you've got a trust corporation appointed, is there the possibility that someone at the firm is willing to be the designated representative or authorised person? So perhaps one of the partners is willing to put themselves forward as that in individual cases, particularly if they have the support of a case manager who can guide that partner on health and welfare decision making. So that's something that you could explore. And at the moment, I'm advising lots of deputies on, for their firm and their circumstances, what's going to work for them. But one option to think about is whether somebody could seek a discrete order authorising them to make decisions about his needs for care and support for the purposes of acting as the authorised person. I think one of the problems, however, that I sort of foresee happening is if the COP does grant that extended authority, are the judges at First Avenue House going to then include within that order a charging clause? Because as I see it, there's no guarantee that they will do that. And certainly when I've seen health and welfare deputy orders where social workers, for example, have been appointed, there hasn't been, and I say independent social workers rather than ones employed by local authorities, I haven't seen with those orders charging clauses. Now, some of you may have seen those, but the reason I query whether this is a problem is because of one of the footnotes in SBB, where Hilda said that a capacitous person receiving direct payments would not ordinarily incur fees for the management of those monies. As a starting point, it is therefore difficult to see why an incapacitous person should be expected to bear such costs. So that does make me, and that wasn't necessarily from memory, a significant feature of the discussions within the hearing. But it does make me question whether, even if a solicitor deputy seeks that extension of authority, is it guaranteed that the COP will also add in that charging clause? Because that's what you'd need to achieve your objective. And if they don't, then you're in a position where you've agreed to make health and welfare decisions and act as the authorised person, that you don't have that ability to charge for doing that. So I think one of the problems I have with that footnote is that, well, you could say the exact same about deputies anyway, because if he had capacity to manage their affairs, then they wouldn't ordinarily be paying fees for the management of those monies. But the reality is the person lacks capacity and somebody needs to help them with this issue. And if there is no alternative but for a property affairs deputy to stick their neck on the line and do this for them, why should that property affairs deputy be expected to do that gratuitously, especially if it might have a prejudicial effect on the delivery of P's care? So I think there are definitely arguments to make in the application. At the moment, I'm drafting lots of applications for specific firms to help, front load this issue. And that's why in SBB, Hilda was considering whether a case manager, for example, is an alternative to a solicitor, who no doubt charges more than a case manager, to act as the representative. So that might be an option here. And it's occurred to me whether the case manager would need to seek a formal deputy appointment to do that. And I'm not necessarily convinced they would, because they could be appointed as a suitable person, and then perhaps charge that in the usual way. And it's then for the P&A deputy to decide whether that's affordable and whether it's reasonably incurred costs, which, if there's no other option, arguably it would be. So that is one way in which some firms are dealing with it. But I think this brings me to my final point, which is an important point, which is about applications for retrospective approval of things that had happened historically. So if you have been acting as a representative or an authorised person without the necessary authority, and you've been charging that to P's estate, then as I see it, there's a very good likelihood that those charges were outside your authority and you weren't entitled to charge those to P, even if they had been assessed by the SCCO. So that might lead you to think or certainly consider whether in some cases you need to be looking at what was charged, and whether you need to be making an application to seek the approval of those charges. And again, that's an issue that I've been advising some firms on how to construct that type of application. Thank you very much for attending. The next seminar that I'm going to be doing, hopefully with Sam Kareem Casey, is about the Knight decision, which is about setting aside reverse indemnities in the civil settlement. In that case, there was a reverse indemnity, and we managed to successfully set that aside. And that has given rise to lots of applications, lots of interesting issues. So we're going to be dealing with that. So thank you very much for attending, and good afternoon.